Welcome everyone to another edition of the Waterstone Legal Update. With me is liquidator and litigator Mr. Damien Grant. My name's William van Roosmalen. I'm one of the lawyers at Waterstone Insolvency. Today we are talking about Debut Homes, which is a recent Supreme Court decision which takes place surrounding a man by the name of Mr. Cooper. Mr. Cooper was the director and part shareholder of a company called Debut Homes. It was a residential property development company. He got into a bit of difficulty and his company was liquidated in 2014 on application of the IRD. There's a bit of background to the case, so we will put a link to the Supreme Court decision down below so you can get some more of the factual background. But I wanted to chat to you today, Damien, about the case, and I've got a few questions for you, if that's okay.
That's why we're here. It is a really interesting case.
Yes.
This is a case which was taken by David Levin, from Deloitte, who is one of the most litigious insolvency practitioners, and I'm the second most litigious. We'll see whether I can catch David over time. The liquidators were successful in the High Court, overturned in the Court of Appeal, and then successful in the Supreme Court. And the Supreme Court actually laid down quite a bit of commentary around, which I think is quite helpful. But just a bit of facts. So you find the director found themselves in the situation in 2012, late 2012, where his property development company was upside down. He goes to his accountant to get some, whether he got advice or not is a question that comes out in the case. But he sat down with the accountant and ran the numbers. And the accountant says, if you complete the projects, you're going to end up with about $300,000 of unpaid GST. The question was, should he have liquidated or asked the secured creditors to appoint a receiver at that point? Because the situation he faced is he owed money to the BNZ and he owed money to a second-tier financier called Jameson, and Mr. Cooper and or his trust had personally guaranteed the debts to the secured creditors. And so what Mr. Cooper did is he said, okay, if I shut the business down now, yep, the Inland Revenue Department will get paid, because if a receiver or a liquidator is appointed and we sell a property, we account to the IRD for GST. If a mortgagee sale happens, then the mortgagee must account to the IRD for GST. But a director continuing to trade on, he can receive money from the sale of the proceeds. He should pay the IRD, or he can do what Mr. Cooper did, and he can take that money and he can pay it to the secured creditors. There's another issue there about the money that was owed to himself under the GST. We're not going to deal with that today because it would go on too long.
So as a liquidator, reading this decision, what do you make of it as a whole, I suppose, for directors and other liquidators who are looking at it from a different lens than the Supreme Court, who are looking at it from a very academic perspective?
Well, as a liquidator, I think it's great. I'm glad you asked me as a liquidator. Given some of my other views, I think that the decision is enormously troubling. But if we're looking at it from a narrow insolvency perspective, there's a two-step process. If you're a director of a company, Mr. Cooper was, you're not automatically liable for the debts of your company. There is a process by which the courts can hold you liable. It's a two-step process. So the first step is they look at the director and say, right, did you breach your duties as a director? And if the answer is yes, then there's a next step that the courts look into is how much should you have to pay to compensate. And in this situation, the courts looked at 3 director duties breaches. And the first was section 1 through 5, commonly known as reckless trading. And they said, all right, Mr. Cooper, did you trade recklessly? And Mr. Cooper said, no, he didn't. And his argument was that the total body of creditors was actually improved, because what he did is he had I think it was 4 partly completed properties. So he completed the properties. He finished them. Now, the result of that meant that the secured creditors actually got more money. And so what Mr. Cooper has said is, yes, there may be some debts to the Inland Revenue Department, but if you look at the reduction in debt to the secured creditors, then the position of the company actually improved. The High Court agreed with him. Court of Appeal said no. Supreme Court said yes. And what the Supreme Court said was, you can't compartmentalise the creditors in that sense. It cannot be, it must be reckless trading to know that your company is insolvent and then continue to trade on in those circumstances. The other really interesting thing that they did in this judgment is that they looked at the insolvency remedies. So you got voluntary administration, you got Part 14 compromises, liquidations and receiverships. And all of those, there is a statutory process by which creditors get paid. The Inland Revenue Department for GST is a preferential creditor, so that means it sits almost at the very top. And so what the what the Supreme Court said is that if a director chooses not to invoke a formal process like a voluntary administration or liquidation, and they do an informal process, which is what Mr. Cooper did.
It has to follow the same principles.
Exactly, it's got to follow the same principles. And in this situation, Mr. Cooper actually turned the principles on its head, because the allegation, which is repeated in the Supreme Court decision, is that he deliberately engineered the situation so the Inland Revenue Department would share the full burden of the loss.
They do strongly infer that he knew the whole time that the liability to the IRD wouldn't be fulfilled, and his argument, Cooper's argument, was that Section 135 reckless trading has got to be assessed whether he was reasonable in his view to continue trading. They shut him down quite heartily, and they reject basically all of his arguments.
It's interesting here that the Attorney General, the state, actually popped in to throw their 20 cents in, which is fairly unusual, and it's the significance of how important this case was.
The Supreme Court goes on to say that there is a duty to not incur obligations unless you have reasonable grounds for doing so, that it's in the best interests of the company.
So you're talking about 136 here?
Yes, so Section 136 of the Companies Act. There is an interesting take on this with the GST component, because when you buy something or when you sell something, GST automatically kicks in, and bada bing, you owe money, or you are owed money back in GST, sitting around 15%. The court was considering whether he breached Section 136 because he was incurring GST liabilities on these property sales, and he was insolvent at the time. So they conclude he was in breach of Section 136. What do you make of that, given that GST is an automatic kind of...
I thought Mr. Cooper's defence here was creative and brilliant. There is a subtle distinction in the difference of the wording between 135 and 136, which I won't go into too much here. But the key question was in 136, it's cause or allow. And what Mr. Cooper's lawyers argued is, well, he didn't do the incurring of the GST obligation is a statutory thing that happens. He was arguing that 136, the 136 is that you cannot incur an obligation as a director without a reasonable expectation that you can fulfil that obligation. And so what Mr. Cooper was arguing was, well, he never entered into a contract with the Inland Revenue Department. This was an entirely statutory process, that the obligation happened independent of him in effect. And I thought it was a really clever argument, and there was a bit of technical distinction between the words that they got down to, but But ultimately it made no difference. The Supreme Court was not persuaded by that.
Well, they said that he knew that the GST obligation would be incurred, and therefore that he couldn't avoid the obligation, and therefore that he was subject to Section 136.
And they said, well, yes, it might be a statutory obligation. Yes, you didn't form a specific contract with the Crown, but you knew that if you did this thing, that was going to incur an obligation, and so Section 136 kicked in, and the Supreme Court said that the decision that he made in late 2012 to continue to trade and trade in the way that he did, they knew that he was doing that, that by doing that he was going to pay the secured creditors and he was not going to pay the Inland Revenue Department, and that was a breach of the specific duty of 136. 136 is also really interesting as well, because again, throughout this judgment, the judges used the phrase rob Peter to pay Paul. And
I think that's the first instance they use, is that it's in respect of 136. It's not legitimate to
I don't think they refer it in 135.
To pay Paul, no, I think that's the first.
So what they're saying is that, okay, you've got a course of action. And so what the director did is well, if I continue to trade, I'm going to pay these creditors, but I'm going to incur the obligation for these other creditors. So even if the total liability of the company comes down, if you're a director and you continue to trade and you know that that's going to result in unsecured creditors or preferential creditors being incurred, then you can be held liable for those creditors that are incurred. There's $28,000 worth of trade creditors that were incurred as well. So that's the treatment of 136 there. The incurring of obligations was interesting, and I think that's also going to play out into another case, which I think is sitting in the Court of Appeal, the Mainsdale case. Maybe we can touch on that at the end.
So just moving on quickly, in terms of Section 131, which is to do with the director, the duty to act in good faith and in the best interests of the company. They reject the previously established Sojourner and Rob objective view, and they say basically this is wrong, the test is subjective, there's no getting around that. They say that the court's not well equipped, even with expert advice, to be making judgments on business calls. So that's also quite interesting.
It was. So Section 131 is, as a director, you must act in the best interests of the company. And so the question was, okay, how do we determine whether a director is acting in the best interests of the company? And a subjective assessment is, what did the company director think? What was in a company director's head at the time we made the decision? And an objective test is, it doesn't matter what's going on in the director's head. Was the decision reasonable based on the actual facts that existed? And the Sojourner and Rob decision, I think it was only the High Court, had said, no, it's an objective decision. Right?
Objective decision.
So as a director, you think you're acting in the best interests of the company. You turn out to be that you are wrong.
But it doesn't matter. Yes, because you're wrong.
So you're not acting in good faith. The Supreme Court rejected that, and they said no.
But they said he breached it anyway because he was preferring some creditors over others.
Well, they pinged him on a couple of grounds. So the first thing, they laid down the case law, saying that it's not for the courts to look back in hindsight. What matters is what was in the head of the director at the time he made the decision. The director can be wrong, but if he thinks he's acting in the best interest of the company, then he hasn't breached 131. But there are some carve-outs, and one of the carve-outs is, if you never consider the interests of the creditors, you don't even consider them, then you're in breach of 131. And that's one of the issues here, was that he didn't consider the interests of the Inland Revenue Department. If anything, he conspired to defeat the interests of the Inland Revenue Department.
Treating them as a bank.
Treating them as a, well, a bank, you got to get paid back, treating them as, I can't think of an appropriate example, treating them as the parents.
Yes.
You know, it's a loan from the parents you never need to repay back. But the other thing that they said was, and we haven't really discussed this, but there was some related party lending and personal guarantees that went on here. And so by completing the houses and selling them down in the way that he did, it meant that Mr. Cooper and his wife's personal financial situation were advantaged. And again, that was one of the things that counted against Mr. Cooper. So he was pinged for having breached Section 131 duty to act in good faith.
That's awesome. Moving on quickly to Section 138. This section basically says company directors can rely on professional advice. It's not strictly a defence. It's not phrased in that way. The Companies Act doesn't say it's a defence. He raises it. The Supreme Court shuts him down. They say basically that his advice was too generalised. And
the accountant's advice.
The accountant's advice that he received was too generalised and was not the type of advice that Section 138 is targeted towards. Does this section provide any defence for company directors?
Well, it's interesting. There was some discussion in the judgment, and I don't think it really went resolved, is whether 138 is actually a defence or whether is if you go to your professional advisors and you get competent advice and you have reason to believe that that advice is competent, and as a result of following that advice you would appear to be in breach of your duties as a director, then the argument is you might not even be in breach of your duties.
Yes.
So it may be kind of a protective measure rather than a defence. But if we look at it as a defence, and that's certainly, I think, how most people think of it, and I don't think it's fully resolved in this judgment. So again, a situation where if you're a company director and you're about to make a decision and you go to your lawyers and you say, look, I want to do this thing. If I do this thing, am I breaching Section 136 or 135 of the Companies Act? And you get a competent accountant or lawyer who looks at that and goes back to you and says, Mr. Director, no, you're not. And it needn't be a professional advisor. It might be one of your fellow directors. And if you have reason to believe that they are competent in that area, then you can rely on that advice. And to that extent, it might be the case of, yes, you have breached your director's duties, but you're entitled to allow on the professional advisors. In this situation, they didn't give Mr. Cooper that benefit. The way the Supreme Court seems to have viewed it is that Mr. Cooper went to his accountant and didn't get advice so much as what would happen if I did this thing.
Yes.
If I stopped trading now, what would it look like? If I kept trading, what would it look like?
What are my options?
What are my choices? And the accountant says, well, if you stop trading, this will happen. If you keep trading, that will happen. The accountant never said you're acting recklessly or not recklessly, whatever. The accountant just simply says, if you do X, Y will happen. And so that wasn't the level of advice that would reach to allow this guy to get protection of 138.
The Supreme Court basically says we're not going to tell you what is good enough, but in this case it's not.
Not enough.
I'm conscious of time, so in summary, Mr. Cooper, lucky, unlucky, thoughts, comments, queries, liquidator perspective, director perspective?
Well, before we answer that, let's just delve deeply. So Section 301 is the remedy section. So what the court said, so there was about 450,000 worth of IRD debt, about 84,000 of it was interest and penalties. Mr. Cooper worked 18 months for the company without pay. Yes. The High Court took all of these things into account and said that he should pay back $280,000, and the Supreme Court agreed with him on that. If you want to look at it really cynically from the perspective of Mr. Cooper, if he had liquidated the business in 2012, there is a very high likelihood that the shortfall to the secured creditors would have been more than $280,000. That was the amount of money he had to pay from the court at the end. Plus, of course, his legal bills, which I'm sure were exorbitant. It's really important to remember that there is no punitive element in any of these breaches. They are simply restitutory. So in one sense, I think it was probably a wash for Mr. Cooper. He was unlucky in the sense that he came across one of the few insolvency practitioners prepared to litigate. Mr. Levin has a reputation for being very litigious, and rightly so, and good on him. But even in that situation, Mr. Levin was unable to recover the full extent of the losses to the Inland Revenue Department, which were $450,000, and that included $84,000 of interest and penalties. So, yeah, Mr. Cooper was unlucky in the sense that he had a liquidator who was prepared to take the issue, but it was probably financially a wash for him. If he had liquidated in 2012, if you ignore the legal costs, he was probably in a roughly indifferent position.
I think it certainly shifts the incentives for liquidators and directors alike. There's some aspects in which directors will now be more cautious, and some aspects, like in the good faith aspect, where they can have a bit more leeway, and they've got a stronger argument to say, no, that was my subjective, honest belief that that was in the best interests of the company, and I did what I thought was right. But the Supreme Court definitely had some firm views against him, and unluckily for him, he was unsuccessful on most of the Court of Appeals.
Yeah, the difference between the Court of Appeal and the High Court is remarkable. But in terms of the case law, this shifts the power balance towards liquidators significantly. And I think the other thing which I touched on before, there's another case called Mainzeal, where the liquidators there were successful for $36 million. I think we're going to find that this Supreme Court decision, which is binding on the Court of Appeal, the Court of Appeal is likely to come out with a win for the liquidators, and I think we're going to see that $36 million substantially increased as a result of the Debut Homes judgment. And if I'm wrong, we will edit that bit out.
Awesome, thank you so much, Damien.
Thanks, Will.
We will put, as I said, the Supreme Court judgment down in the link below. We're always available for free 30-minute consults if you've got any further questions, and are considering whether Mr. Cooper might be you in the near future. So thank you so much, and cheers again.
Thank you.
Thank you.